then you have trade financing aspect to it, and you have a simple contract between two parties to it. And this whole Inco terms, bills of lading, and letter of credit actually fit in very well, seamlessly into one international sales transaction. Just now, uh, the let's begin with this chart. I hope everyone can see this chart that I've put up. Now, the question of a general international sales transaction, you have parties that enter into a normal contract to purchase goods and to export goods, to sell goods, etc. But the question then arises about transportation of the goods and how to pay for the goods, because the parties are located in different jurisdictions, different countries. It is very hard for one party to keep track of what the other party is doing. For example, if you go to a store and buy a pen, you go to the store, you pay, and you immediately get the goods. You get your pen as at the same point. So there's no question of you having to wait for delivery at that point. Whereas if you buy something on Amazon, you pay for it and then you wait for delivery. But in that case, because there is an understanding that Amazon is responsible for delivering the goods to you and takes the risk for delivery, you have no issues as far that whether delivery will not take place or etc. But in an international transaction, that's a completely different issue, because if I am exporting goods from India to, say, the UAE, the buyer has to be certain that the goods will be received, and the seller will have to be certain that the payment will be received. Because if I went like a normal transaction for a pen, that I said, all right, I'll send the goods and then you pay me afterwards, I will send the goods, and if he refuses to pay, I have no way of recovering other than going to Dubai and trying to recover money from him. Or if he pays me before and I don't sell the goods, then he has to come all the way to India and secure payment. And that's why you have developed this elaborate system, which is described in this chart here. So I'll break this up into three parts. First, we'll discuss the contract, which will include the Inco terms. Then we will talk about two things that probably take place simultaneously. One is the transportation of the goods, where you have the bill of lading and charter parties. And the third is the letter of credit. Now, first of all, when parties in these cases enter into a contract, they will sorry, I'm told my screen is not yet shared. I'm just trying that. 1 second. Give me a moment. I hope you can see the screen now. Vivek, can you confirm?
Yes, we can see it.
I
Go ahead.
apologize for the earlier inconvenience. So in any case, let's get back to this. Now, this chart will show in detail a international sales transaction, and we'll go through this first with the Inco terms, then the letter of credit, and then the transportation and the documents involved in the transportation of the goods. And this will completely explain how a maritime or international sales transaction will take place. Now, first of all, the buyer and the seller will enter into a sales contract, a normal contract that people enter into day-to-day basis. But in this case, because it's an international sales contract, and because the goods are going to be transferred from country A to country B, there are certain nuances involved. First and foremost, the goods will be transported by a third party. So you have to understand, when you're handing over the goods to a third party, there's a question of responsibility as to who is responsible once the goods have been given to the third party for the safety of the goods. And that's where the Inco terms have been developed by the ICC. and which have been adopted widely by various people, in the trade in general. And you have Incoterms for multimodal transport, and you have Incoterms for maritime. And we'll only be dealing today with uh, maritime. Now, let me give you, I've given an Amazon example earlier. Let me give you one more example of how it generally works. If you order something from Amazon which is delivered from abroad, you will see to it that in that transaction, you not only pay for the goods, you also pay for the import duty. And then the responsibility is of Amazon or the seller on Amazon to send the goods to you. Now, that doesn't work generally in international trade. In fact, in sometimes if you have a multimodal transportation contract, that might work. But in the contract we are talking about today, that is not the case. In a contract that we're talking about today, the parties will agree that the seller will send some goods to the buyer, and the seller will seller's responsibility with respect to the goods when they're being transported will be defined in the contract by the Incoterms. Now let us understand what the Incoterms are. Now, rules for the sea and inland water transport. Uh, First of all, the Incoterms are defined by the ICC, and they are generally used by everyone across the board to provide some uniformity in international transactions, because it would be very difficult if every country had its own definition of what a particular term meant. This then transactions between two people from two different countries would become nearly impossible, because every country would have its own definition. Every person would act according to his own law, which would benefit him, and the other person would try to act according to some other law, and there would be total confusion. But that's why the ICC has provided these rules, and these are generally followed. Now, broadly speaking, with respect to transport by sea, there are four major Incoterms. And in fact, if you see, these other Incoterms are for other modes of transport, which which include the Amazon kind of example where you have delivery at your door. In any case, the four rules for sea are FAS, which is free alongside ship. Now, if you see from this graphic, the uh, the seller is in blue. He will bear the cost and the risk of only transporting the goods to delivery along the ship. He will do the export formalities, deliver it at the port, and there his responsibility ends. Thereafter, the buyer will have to provide for the transportation. So the main idea here is the transfer of risk. For the seller, the risk with respect to the goods ends as soon as he delivers it on the port, and there the buyer then takes over the risk and has to see to it that the goods are transported to him. The second is, and probably a more common usage is FOB, which is free on board. Now, in this, the seller will put the goods onto the ship. Earlier, there used to be an understanding that when the goods go over the rail of the ship, that is the outer edge of the ship, once they have transferred over the edge of the ship, the risk passes. But now it has been clarified that the risk in a FOB transaction will transfer to the buyer only when the goods have been loaded on the ship. So that means that if there are 10 packets to be loaded, if only 5 packets are loaded, that means the risk has not transferred yet. All 10 will have to be loaded on the ship, and then the risk will transfer. But once the goods have been put on the ship, the risk then transfers to the buyer. So if anything happens to the goods during the transportation of the goods, it's on the buyer. Then you have CFR, which is again uh, quite common. I mean, FAS really you don't come around to that much, but CFR and CIF especially you do. CFR is again cost and freight. Now, in a case like this, the risk again transfers to the buyer once the goods are loaded on the ship, but the seller bears the cost of transporting the goods to the port, to the home port of the buyer. And in CIF, this is the final one, you have the cost of shipping plus the risk remains with the seller till the goods reach the port. If you see here, the diagram clearly shows that you have the costs, the cost is up to the port, risks is a you have the risk up to the ship, and then the risk up to the port is secured by insurance. Now, these issues have been looked at by our courts, and they have generally defined each one of these terms, and then you can get a broad understanding of how Indian courts understand this. Now, in this case, this is a Delhi High Court judgment in which the buyer entered into a CFR contract, cost and freight contract, and then but also took insurance for the goods. The seller also took insurance for the goods, and there was some issue with the goods, and the court had to decide as to who has the insurable interest. The court eventually came to the conclusion that since this was a CFR contract and the risk transferred to the buyer as soon as the goods were loaded on the ship, the insurable interest has also been created in favor of the buyer and not in favor of the seller. Now, but the court has also looked at the various terms like FOB and CIF. And if you see this, coming to the case in hand, they're referring to another case law. The sale was FOB basis, even when the contract of insurance proceeded on the basis that the transactions between the buyer and purchaser would be covered by a policy of CIF. The distinction between CIF and FOB contract is well recognized in the commercial world. While in the case of CIF contract, the seller, in the absence of any special contract, is bound to do a certain thing, like making an invoice, shipping the goods, and delivering and procuring contract of insurance, which will be delivered at the destination. And in the case of FOB contracts, the goods are delivered free on board. Once the seller has placed the goods safely on board at his cost and thereby handed possession of the goods to the ship in terms of the bill of lading or other documents, the responsibility of the seller ceases and the delivery of the goods to the buyer is complete. The goods from that stage onwards are at the risk of the buyer. Then the court looked at the particular facts here, and adverting to the facts of the present case, as per so and so, the contract was on CNF. CFR is also known as CNF, but it's mainly technically known as CFR. Under CFR, under CFR contract, the risk passes to the buyer when the goods have been placed safely on board the vessel, and therefore the risk of the plaintiff ceased once the goods passed through the ship's rails. Actually, now the ship's rails concept has gone, as I explained before. If you look at the explanations given by the ICC in the Inco terms 2010, they have done away with ship's rails, and in fact now, as I mentioned before, the risk is only transferred when the goods are placed on the ship. Accordingly, in the present case, when the cargo was delivered on board, the risk passed to the buyer. So as we see this makes it clear that these Inco terms are primarily for transfer of risk. And once the parties have agreed to this, they will agree to this contract as per, and that will determine the cost of the goods. The other terms that you would have to look into the contract are the mode of payment. There are two ways that you can do an international transaction. You can do it by documentary credit, which is in the form of bills of exchange, or you can do it by letter of credit. Sorry, not by documents or by documentary credit. So by documents is bills of exchange, and then you have your letters of credit. We are going to deal only with letters of credit today, but both of these are international payment, international financial transactions for trade financing, and again they go through the banks. Now, what is the need for a letter of credit? As I explained before, because the parties are in different jurisdictions and they don't know each other very well, or even if they know each other very well, in an international transaction, it's very easy to hoodwink one or the other. You need an intermediary to help you finance the deal. And that's why you have a letter of credit. Now, in this scenario, the the letter of credit is to be treated as a separate and independent contract. It is a contract with which is a deal with the bank and has nothing to do with the sales contract. So, to make this clear, if there's a breach of the terms of the sales contract, it does not necessarily affect the letter of credit. In fact, it generally won't affect the letter of credit unless there's some sort of a fraud of such an egregious nature that it undermines the entire transaction. But just because goods were not supplied up to a certain specification, or the quantity was not as per the contract, that will not void the letter of credit. And that is for a reason. The banks don't want to get involved in your transaction. They have nothing to do with your goods. They are only interested in financing your transaction. They will deal with documents. The bank will look at a document, see if the documents are in order, and deal with it. Now, what are the documents to be presented to the bank will have to be agreed by the parties under their letter of credit, under the transaction. So when you enter into a transaction, in your contract, you will set out the documents that are required to be presented to the bank for payment. So when you so how does the letter of credit work? So once you have entered into the contract, once you've agreed to the various terms as to what documents are required to be paid, to be presented for the payment, etc., the parties often, before applying to the bank, will exchange drafts of the letter of credit. They will agree between themselves the terms of the letter of credit, and then the buyer, after the parties have agreed, and this happens quite often, this is not shown in this, but the party generally will negotiate even the terms of the letter of credit. And once that has happened, the buyer will then apply for a letter of credit to his bank, which is called the issuing bank. The issuing bank will then send the letter of credit to an advising bank. Now, the advising bank could be an independent bank or could be the bank of the seller. It could be either or. And the advising bank will look at the letter of credit, which is sent by something called a SWIFT message. SWIFT is a way of mode of communication between banks. I'm forgetting the long form of this, but it is basically a conglomeration of banks which have come together. And in Belgium, they have set up this organization called SWIFT. And by that, that organization has come up with various rules as to how banks can message each other. I will show a letter of credit to show how this means or how this works. But before that, so the issuing bank will send a SWIFT message to the advising bank. The advising bank will then check the letter of credit if it is in order as per the rules. And the rules governing letters of credit are the UCP 600 rules currently, which are the uniform customs and practices for documentary credit. These are rules again formed by the ICC, which are very detailed rules which tell how a bank should evaluate a letter of credit, how banks should deal with the letter of credit. For example, the UCP provides that when a bank receives a letter of credit, and if it has, and the documents under a letter of credit, if it has any issues with the documents, it has only 5 days to reply, to send the documents back. If the bank does not send the documents back in 5 days, it has lost its opportunity to deal with it and will then have to confirm and pay as per the letter of credit. In any case, once the advising bank gets the message, it examines the letter of credit and then forwards it to the seller. In the meanwhile, obviously, the seller has to transport the goods. And once he has transported the goods, I'll come to this aspect later, he will get the transport documents from the carrier. The transport documents normally will be the bill of lading and the other documents which are specified in a letter of credit. Now let us just see what kind of documents they will be. This is a letter of credit in one of the matters I had done. If you see, it provides the documents required. You have signed invoices, quadruplicate with so and so, full set of on-board ocean bills of lading. Then you have further, these are the other additional conditions, uh, negotiable instruments along with CIPA, so and so. So these are the documents, insurance, etc. These are the documents required to be presented by the uh, by the buyer, sorry, by the seller to its bank for forwarding uh, to the buyer. Now, once the letter of credit has been received and once the documents have been forwarded uh, by the carrier to the seller will send the documents to his bank. The nominated bank will then forward the documents to the issuing bank, which is the bank of the buyer. The issuing bank will further forward the documents to uh, to the applicant once the applicant has made payment for the same. Only when the applicant then has the documents can he go and present them to the carrier to receive custody of the goods. So the chain is is only based on documents. The bank here is not dealing with the goods at all. The seller gives the documents to the bank, to his bank. The nominated bank or the seller's bank will then give the documents to the issuing bank or the buyer's bank. The buyer will pay his bank, and then the bank will give him the documents. So the bank is not dealing with the goods at all, purely with the documents. And once the documents have come in the custody of the buyer will go and present these documents to the carrier, and the carrier will, on that basis, transfer the goods to um, to the buyer. Now, some important aspects with respect to the letter of credit is that since the banks only deal with documents, they take this very literally. So, for example, in this case, the applicant had to, this is a case for the applicant or the buyer entered into a contract with steel suppliers from Korea. Now, one of the conditions in the letter of credit was that an insurance policy covered by the would be taken by the applicant, and because this was a CFR contract, but the seller would have to send an email 5 days uh, within 5 days of shipment to the buyer and the insurance company, and a copy of such email to accompany the documents. So what this means is that once the goods are shipped, the seller had to send an email with the documents to the buyer and the insurance company, and a copy of that email was to be presented along with the documents to the banks. Now, the case of the buyer was that he did not receive the email as per this condition. Neither did the buyer nor the insurance company receive the email. But the email was in fact presented, but a copy of an email was presented to the bank by the seller. Now the copy, it's very interesting to note that the words here are copy of such an email. Now, copy of such an email, what was presented to the bank in this case was not the email itself, not a printout of the email, but a just a printout of a Word document which was in the format of an email. It was not the actual email, but a copy of that email made in Word. Now, so the seller's case was that this is a fabricated document. This document, sorry, the buyer's case was this document is not valid, and I that's why the letter of credit they have not uh, accepted they have not acted as per the terms of letter of credit, and that's why this letter of credit cannot be honored, and the bank should be injuncted from making payment to the seller. Also, this is a very fascinating background to this case, because what what had happened here was the contract was entered just before the lockdown. The goods were sent just before the lockdown came into force, and once the goods were sent, the the buyer claimed force majeure on the made a claim of force majeure on the basis of the lockdown of COVID, and sought to renege on his contract, and that's why sought an injunction against payment being made under the letter of credit. The seller had sent to the bank a printout of an email, as I said, which was in the Word format, but which was not exactly what you would call an email. But that doesn't matter, because, for example, under the UCP, since the bank deals only with documents, the UCP provides, for example, that under Article 34, a bank assumes no liability or responsibility for the form, sufficiency, sufficiency, accuracy, genuineness, falsification, or legal effect of any document. So the bank, and I was appearing for the bank in this case, and I said that, listen, we have received a copy of an email, and that is sufficient as per the UCP, and the court accepted this document. It is it is clear, therefore, the that the bank has to only look at the document, not even look at the form of the document, or whether the document is actually legally the legal effect of the document. It just has to see whether the conditions of the letter of credit have been fulfilled and the documents as required by the letter of credit have been presented to. Now, so this is with respect um, to the UCP. But obviously, in law, letter of credits can be the injunctions can be sought under letter against letter of credit, and they can be sought. The law on that is has been crystallized, and it's very clear. And this is a judgment of the Supreme Court, once again setting out the law on injunctions, which is very narrow, and it says that the law can be summed up as such: the court must be slow in granting an order of injunction restraining the realization of a bank guarantee or letter of credit. There are two exceptions to the above rule. The first must be that it must be clearly shown that a fraud of a grievous nature has been committed, and to the notice of the bank. And second is that injustice of a kind which would make it impossible for the guarantor to reimburse himself, or would result in irretrievable harm or injustice to one of the parties concerned, should have resulted. Now, and it clarifies that it is not enough to allege fraud, but there must be clear evidence as to both of the fact of the fraud as well as the bank's knowledge. Now, I go back to the example I gave before of the email not having been sent to the buyer, but a copy of the email having been sent to the bank. Now, if the buyer, when he immediately found out of the fifth day that the seller had not sent him the email, he could have immediately informed the bank that the seller has failed to perform as per the conditions of the letter of credit, and therefore there is a fraud on part of him. Then the bank would have knowledge of the fraud. In the facts of the case, the buyer did not inform the bank, so the bank proceeded as per the documents, and they had no knowledge of the fraud, and therefore there was no question of granting an injunction in that case. So if you're going to claim any sort of fraud or trying to get out of a letter of credit, it is a very narrow window that you have. And you must see to it that if you're going to claim some sort of fraud, you better inform the bank firsthand, even before the bank negotiates. So once you know of the fraud and before the bank has dealt with the documents, you need to inform the bank about the fraud so that the bank can takes so that then the bank cannot say that the fraud was without its knowledge. Now, once we have done with the letter of credit, let's now deal with the transportation of the goods. When you are the transportation of the goods generally will take place by sea, sometimes by air, but mostly by sea. So that would mean that the seller has to enter into a contract with with a third party, which is the carrier for the transportation of the goods. When the carrier takes the goods from the seller, it it can happen in two ways. Now, I have been asked to talk about bills of lading and charter parties. Now, these are two very different things because a charter party. I'll go to the charter party first because a charter party is relates to hiring of a ship. So you are taking the entire ship. Normally, if you're taking a charter party, you are entering into a contract with the owner to take over a ship for a certain period of time. That's called a time charter, or for a particular voyage, which is called a voyage charter, or you are interested in taking over the ship to run it, which is called a bareboat charter or a demise charter. Uh, so we will just look at that. Now, a demise charter are those in which, in turn for payment of hire, possession of a chartered ship is given to the charterers, who provide the crew and all supplies, pay running all running costs, and undertake the responsibility of the ship owner to those whose goods are carried on the vessel. In sum and substance, a demise charter is like a dry lease. You just take over the ship and you run the ship as your own. In fact, in admiralty law, a demise charterer or a bareboat charterer is a de facto owner of the vessel, and the vessel can be arrested for any fault of the uh, of the of the of the demise charterer. A time charter is is for time charter, whether for a period or for a trip, are those under which, in return for payment of hire, the vessel's employment is put under the orders of the charterers, while the possession remains with the owners who provide the crew and pay the ordinary running costs. So, in a time charter, I'll tell you what can happen. I can take a vessel on on a bareboat charter. So I will take the entire vessel. I will hire my own crew, man the ship, and then I can give it on a time charter to someone else who will say that I want this ship for 1 year. And when that happens, the the charterer only has the entitlement to the ship for a year, but he does not run the ship. I run the ship on behalf of the charterer, and that's it. And a voyage charter are those in which the owner agrees to perform a voyage or one or more designated voyages, where again the anyone who wants to transport cargo in bulk. For example, a voyage charter will generally be where you want to take the entire ship for your cargo. So an example for this would be a company like Sail, or someone who wants to transport coal from different from a country from Australia to India for its plants, will take an entire vessel on a voyage charter for transporting coal from Australia to India. And in that case, the owner will take the entire cargo for sale from Australia and give it back to sale in India. Then you have something called slot charter, which is something of a new thing which has evolved in the day of containerization, where you can take certain portion of the ship on charter. And now, if I have taken an entire ship for my own goods, there's no need of a bill of lading to be issued. But a time charterer or a voyage charterer who has taken it for carrying goods of other people, then a bill of lading will be issued for the particular goods that are carried on vessel. For example, a time charterer will then hire the vessel to numerous people who will be entitled to use who will be entitled to transport their goods on the vessel. And to each one of these persons, he will issue a bill of lading. For example, our seller, he enters into a contract with the owner, and the time charterer as the owner, because he has chartered the vessel, will issue him a bill of lading with respect to his goods, and that bill of lading will be the contract for the carriage of the goods. Now, once the bill of so now we'll come to the bill of lading. So we have the charter parties. Now we come to the bill of lading. Now, a bill of lading is a document uh, which is of very great importance in this entire transaction, because it often and most times is a document of title. Now, what happens in a bill of lading is once I enter into a contract with a carrier and the carrier loads the goods on the ship, he issues me a bill of lading. A bill of lading can be of two types. It can be a negotiable or a non-negotiable bill of lading. A negotiable bill of lading is one in which is the document of title and can be transferred from one person to another by a simple endorsement. So, and a non-negotiable bill of lading will mention a particular person as the consignee who is supposed to receive the bill, and that person alone is entitled to take the goods from the carrier. So if you see, this is a bill of lading issued by sample bill of lading issued by Hapag Lloyd, which is a very big company. If you see here, the consignee, it clearly says not negotiable unless consigned to order. Now, what this means is that instead of consignee here, a named consignee, which would make this a non-negotiable bill, if you say X means any person or to order, it becomes an order bill of lading, which is negotiable. In this case, I'm sorry, I just skipped a little ahead. So when a bill of lading is issued, if it can be in three forms. It can be what is called a bearer bill, in which case it's a negotiable bill and there is no consignee as such named. It may say only to order, and in that case, the bill is uh, will be a document of title in the hands of whoever is in possession of the bill. So if my seller goes and gets a bearer bill issued from the carrier, the seller continues to hold title of the goods till the bill of lading is in his hands. The moment he hands it to someone else, a second person, that person is entitled to the title of the goods, and so on and so forth, whoever is the holder. The next is what is called an order bill of lading. In this case, the order bill is one where the consignee is described either as to order or X or order or to the order of X. So what this means is once you have it's a named consignee or to order, it means that the bill can then be endorsed to someone. An endorsement is basically, suppose it's the bill is to the or X or order. X receives the bill. X doesn't want the goods. X will then endorse it to some person Y. He will just sign at the bottom and endorse it to Y, and then Y becomes entitled to receive the goods. Then you have the straight consigned bill of lading, which is what I was talking about, a non-negotiable bill in which the consignee is named. So that is called a straight bill. And then you have a final bill of lading, a kind of bill of lading which is issued often, but which really has no value, is called a house bill of lading. Now, a house bill of lading is issued by something called a freight forwarder. A freight forwarder is an aggregator. So if I'm a small person exporting goods, I will not deal directly with a carrier. I will go to a freight forwarder in my district, in my city, wherever I am, and the freight forwarder will take the goods and will see to it that they are transported on whichever vessel to my destination. And the freight forwarder will enter into a contract with the carrier. The carrier will issue a bill of lading, and the freight forwarder will issue his own bill of lading to me, which is called a house bill of lading. The legal sanctity of that bill of lading is really questioned, and I would say that you to have a title of the goods, you should have a bill of lading issued by the ship, by the master of the ship it's himself. The bills of lading in India are covered by two acts. One is the Bill of Lading Act, and the other is the Carriage of Goods by Sea Act, called COGSA. Now, the Indian Bill of Lading Act is a very old act, but it does, and a very short act, but it does one simple thing. It creates the rights in the endorsee. So it wanted to clarify the position that there was a practice of endorsement, and this bill made it into law. The practice that was carried out by the merchants, that once a bill is endorsed to a person, that endorsee enters has all the rights of the original person who entered into the contract. So what this means is that the seller who had entered into the contract with the carrier and the bill of lading was issued to the seller, if the seller endorses the bill of lading to the buyer, then it is as if the contract of carriage was between the buyer and the carrier. The carrier does not have to enter into an independent contract with the buyer, neither does the buyer. Once it is endorsed to the buyer, then the buyer is in the position of the seller and has all the rights of under the bill of lading. The next, you have the COGSA. COGSA is deals with so seeks to unify you make the rules relating to bills of lading uniform. There are various international conventions which have then been made uniform by incorporating them into Indian law, and COGSA will apply only to bills of lading issued in India. So the only thing to be remembered is the COGSA will apply to bills of lading issued in India, and COGSA also has a 1 year limitation period. You could you could sue under the contract, but if you want to sue under the Indian Carriage of Goods Act, Carriage of Goods by Sea Act, it has to be within 1 year of the incident, whichever has given rise to your claim. Uh, so these are the basics of a of the carriage of goods. You can have a charter party if you are selling, if you're trying to take an entire vessel for transporting your goods, or if you're transporting goods which are going to be carried, which are only going to be part of the goods carried on the ship. A bill of lading will be issued, and this bill of lading will determine the title of the goods, and which is an important document which will always be have to be presented even under the letter of credit transaction, because that bill of lading will allow the buyer to um, take custody of the goods. I think my 40 minutes are up. Vivek?
Yes, sir. Yes,
Yeah.
sir. Hi.
Yeah.
Uh, Thank you, sir. Now we'll quickly move on to Q&A session. If you guys have any question to put up to sir, you can just put it in your chat box and I'll put it to sir. I think I saw a few questions above. I'll just see. We had a question from Yogesh Tendulkar that is there any limitation of letter of credits?
Sorry, limitation. I don't get what you mean by limitation of letter of credit. Uh,
Limit. Yeah.
the
Hmm.
Generally a letter of credit can be. I mean, if you're talking about amounts, it can be for any amount whatsoever. Depends on your standing with your bank whether they will open letter of credit of a certain amount for you, depending on your business with the bank. So I don't understand what other limitations there are, but the letters of credit are governed by the UCP 600 generally, so that those rules will impose certain limitations on the format of a letter of credit, on the manner in which it has to be viewed, it has to be examined, and then obviously you have SWIFT, which is the way of exchanging letters of credit. So you can only forward the letter of credit as a SWIFT message, because that is an authenticated message between banks, and banks will respect only authenticated messages since they are dealing only with documents and they're not dealing with the goods, and they will have to be certain about the message is received from an authenticated bank.
Okay. Yogesh, sir, if that answers your question, or if you want, you can put the question in a good manner. I'll quickly move on to the other question asked by Amrut Anand. Sir, what will be the legal framework in case of the e-bills of lading that might be issued? Electronic bill of lading.
I mean, again, I think if there will be an electronic bill of lading, it will also have to first go through the seller to the bank. It can't be directly issued uh, to the sorry to the buyer, because if the buyer gets the bill of lading before the goods have been before payment has been made, he can take over the goods without making payment. So if I'm going to have an e-bill, it will there'll have to be a procedure to see to it that the e-bill, the custody of an e-bill will have to be through this letter of credit transaction, which is again an electronic transaction for the most part. So instead of a physical bill, you will have an electronic version of the bill, which can be accessed probably by whoever is authorized in the name as an endorsee. We can have some authorization. You can have, instead of an endorsee that you have a physical signature, you could do an electronic endorsement to a particular person and give a password or something to that person, and he can access it, and then he can send it to someone else. So there will have to be a mechanism to see to it that it can only go to a particular person of the sellers and the carriers choosing, which will have to be worked out. But it will have to be similar to what we have today, but in an electronic form.
Okay. Okay. Mr. Arjun is asking, sir, if we receive payments against bill of lading as a seller, can this be applicable in international trade?
Uh,
If
I don't see how you'll get payment
I,
against a bill of lading, because the bill of lading is only the contract for carriage of the goods. The bill of lading will is a part of the transaction, and the payment will be made only when the entire transaction has been fulfilled and the bills have been presented to the buyer. Uh, and I mean, I don't understand otherwise how. And these are international transactions. I mean, we are
Hmm.
talking about international transactions. This could also be done domestically. Don't get me wrong. Letters of credit are also there are also something called inland letters of credit, which are issued domestically. But in and bills of lading are also issued domestically. But we are talking about international transactions generally. So everything that we have discussed here applies to an international transaction.
Hmm. Hmm. Mr. Ajinkya has asked, can you please share us to in which case do most disputes arises in case of bill of lading or in case of charter party? I would appreciate your views with respect to litigation and disputes arising out of two situations. It's a very general question asked.
Yeah, yeah, and this is actually In both, I mean, obviously there'll be more cases of bills of lading because more bills of lading are issued than charter parties. There are a limited number of ships, but the ships are carrying unlimited amount of goods. Today, everything that the most of the imported goods we're using are transported by sea, which means that whenever they are transported, numerous bills of ladings are issued, and there will always be issues about damage to goods on the sea or late delivery or delivery to the wrong person, and those sort of issues will arise in bills of lading. When it comes to charter parties, the issues will be mainly what I have come across is that the charterer goes bankrupt and fails to pay hire to the buyer, and then those disputes arise. Or if many times the charterer will seek to put fuel in the vessel and not pay, and then the issue will arise who has to pay for these sort of this fuel, because the person who's supplying the fuel will look both to the owner of the vessel and the charterer. And other issues that can arise out of charters are damage to the ship. So if I've taken the ship on charter as a demise charter, for example, and I damage the ship, then the owner will have a claim against me. So there are various disputes that can arise out of charter parties, but I would say that obviously bills of lading is more likely because there are millions and millions of goods being transported every day, and there is always some issue arising with the with whether the goods are damaged or they've been delivered to the wrong person, etc.
Okay. I hope that answers the question, sir. I'll move on to the other question asked by Niladri Bandyopadhyay. Bill of lading is the evidence of a contract. What is the contract being referred to?
So actually, bill of lading is is not the ultimate contract. Often, a bill of lading will also refer to a charter party. So, a bill of lading will incorporate further terms of a charter party also, and and that may be the contract between the parties. So, and one must also realize that a bill of lading also has very detailed terms and conditions annexed to it. So it is a contract not only contained in the bill of lading, which will have the terms and conditions, but will often incorporate the terms and conditions of a charter party, and that is the contract between the parties. So yes, the bill of lading by itself may not be the only contract. There's also a charter party that is involved, which will be which will be incorporated by reference in the bill of lading, and this has been recognized by UK and Indian courts repeatedly, that if there's a direct and specific incorporation of either an entire contract or a specific term of another contract, that will form part of your bill of lading contract.
Okay. Okay. I'll does the title pass? Okay. Niladri has asked one more question. Does the title passes even before payment is received by the seller? Yeah.
This is why the bill of
Hmm.
this letter of credit transaction is interesting. Ostensibly, once the bill is endorsed in favor of someone and they come in possession of it, the title passes to them. But because we are doing in the letter of credit transaction here, the documents such as the bill of lading will only go to the buyer when he makes payment to his bank. So the seller will give the bill of lading to his bank, the issuing bank, the nominated bank. The nominated bank will then hand over the documents to the issuing bank, which is the buyer's bank. The buyer's bank will hand over the documents, which is the bill of lading, to the buyer when the buyer makes payment to the bank. So only on payment being made is the bill being transferred to the buyer. But there's a caveat here that it may often happen that you have some sort of a credit arrangement with the bank, and the bank will allow you to take the bill of lading even before payment. That depends on your facility with your bank. But the point is of the I would also like to point, even if that facility exists between the buyer's bank and the buyer's bank, once it has approved of the documents, has to pay the seller's bank. So payment will be made to the seller, irrespective of whether the buyer has paid to his bank immediately, or whether they have a credit understanding, some sort of an arrangement.
Okay. Last question for the day, asked by Mr. Nihal Sheikh, is asking in what cases the owner of the vessel is liable for the damaged goods on board.
In all cases, once the bill of lading is issued by the master of the vessel, and once that happens, the master is a representative of the owner, which in this case could also be the demise charterer, and or the actual owner of the ship, and you are entitled to sue them for the damage to the goods. So if you are transporting goods on using that on Hapag-Lloyd ships, if your goods are damaged, you can sue Hapag-Lloyd for the damage to the goods.
Okay. I think that's it for the day. I hope everyone enjoyed the session. That was a very good and intriguing session, I believe. And I'm sure we may not have covered everything, but surely Sir would have given a glimpse of uh, all the topics, all the essentials, bills of lading, letter of credit, and charter party agreement. With that being said, we have come to the closure of the session. It is my privilege to have Sir on a platform, and that he took his valuable time for us and interact with us. I'm thankful to you, sir.
Thank you for giving me this opportunity. I just want to say that I'm sorry if I couldn't go into details of things, because each one of these subjects is enormous, and hopefully someone will give you a much more in-depth session on each one of these subjects, because they're interesting and they're important, and they will take a lot of time.
Yes, indeed, sir. As we have got into this journey, we will gradually touch each of the topic and have a detailed discussion and courses on it. We promise to conduct many more sessions like this. Thank you, everyone. Thank you, all the participants, for joining us. And be stay tuned with us. Follow our LinkedIn page, Instagram page, Tathya-walk the law. We are specializing into maritime law. Thank you, sir. Thank you for
Thank
your
you.
time, sir.
Thank you very
Thank you
much.
so much. Thank you, everyone.